The next few recordings will be about the three arms of government. We'll start this one today with the judiciary. So in this recording, I'll explain the role of the court system in our current system of governance. We're going to look at the mechanisms that allow the institution of the courts to function within the Australian sort of governance structure, and we're going to look at the role of in particular the High Court and how it has this unique position in interpreting the Australian Constitution. I'll also look at the other end of the scale, examining the Magistrates' Court as the clearinghouse in the court system, and then finally I'll discuss judicial appointments and the systems of tenure that judges have. The first step here, though, is to resolve some ambiguity. You see, the term the court and the judiciary can mean different things in different contexts, and as you move forward through a structured legal education, you'll be exposed to those used in a variety of contexts, and it can take a little bit of time in order to pick and understand what it is that people mean when they use the term the judiciary, or more importantly the term the court. And so there's really three main ways that the term the court gets used. You've got the first one, which is as in a particular institution. So, for example, the High Court is a court, and it includes all of the judges in that court, all of the processes, all of the physical structures involved in that. So when we refer to the court, the Magistrates' Court of Queensland, or the Privy Council, or the Supreme Court of the Northern Territory, that's looking at and using the term court as an institution. The second way that we use the word court is usually to describe very much the physical place. When practitioners use the phrase, I have to go to court, that's used to describe, or I'm currently in court, don't call me. That really describes the physical place or location. So what they really mean is the courthouse, sitting in front of a judge in proceedings of some sort. The third, and a slightly more abstract way that we use the term court, is to refer to a set of judges in a particular court as in the institutional sense. So, for example, when we refer to the Mason Court, that is the set of judges sitting on the bench of the High Court from the mid-80s to the early 90s, under where Chief Justice Anthony Mason was the Chief Justice at the time. And so that we can use that more abstract use of the word court to really describe groups of judges, usually in a collection of some sort. Now, the term judiciary doesn't come up as much in general parlance, but it really has two definitions that we're interested in. The first is, when we talk about the judiciary, we actually think of it in terms of one arm of government. It is the institution of government that resolves disputes and interprets the law. It's also referred to as the judicature. The second way that we use the term the judiciary is as a body of officers. When we talk about the judiciary, we mean all of the judges and magistrates in a particular system. So to step back a second and think back about the legal history of Queensland and of Australia, and we refer to the sort of earlier times where there's a single autocratic ruler, a monarch. Prior to there being a concept of separation of powers, the monarch has absolute power. The monarch makes the laws, resolves disputes between subjects, and enforces it. However, as through a series of historical events, as time has passed, separations of those powers exist, and again, it's a very critical core component of our system of Westminster governance, that the judiciary has a separate and distinct role in the system. And so the primary role of the judiciary is to resolve disputes. That is, when two citizens, or from time to time a citizen and an arm of government, needs to have their own individual rights in the particular law clarified in order to determine who's right. And we think of this from a very practical perspective, that parties, rational individuals who know what their rights are and are very clear about them, don't come into dispute because they would know which of the two parties was going to win. And of course the process of going to court is both expensive, time-consuming and traumatic. However, this isn't the case. It's quite often that people are both confused about what their relative rights are and require the judiciary to make a decision to determine who's going to win and who's going to lose in an adversarial system. And so in reaching that decision, the courts will go hear submissions from both parties, interpret the relevant legislation and case law, and from time to time, though, the judiciary needs to make law, and that it will take the existing precedents, examine the facts of the matter in front of her or him, and determine that, well, this particular matter doesn't fit any of the existing laws, either legislation or case law. And so there is this idea that the judiciary from time to time needs to actually make new legal rules. And so you may be thinking, well, hang on, that's problematic. Isn't the role of the legislature, isn't that Parliament's job to make the law? And you would be right. This is a sort of a long-standing problematic area of the judiciary in terms of judges making law. And as I'll discuss in more depth later in this recording, judges aren't elected. That the parliamentarians, so that the houses of parliament are elected in order to make laws. Judges, however, aren't elected officials, and this can be problematic. However, it must be stated at this stage that courts do possess and do have the authority and I guess the legitimacy of the ability to make laws in those situations, to increase and expand the common law of Australia and of Queensland. So when thinking about the underlying authority and legitimacy that the courts have, it's helpful to think of the courts, in fact all of the arms of government, as necessarily deriving their legitimacy from the sovereignty of the Crown. Now, you may recall from earlier recordings the concept of the active state doctrine. That's really the idea that a particular court can't question the powers or the legitimacy of the authority that has been vested with. In other words, that where a person comes before the court challenging the underlying sovereignty of the Crown, for example here the entire nation of Australia or the state of Queensland, the court can't challenge that. The reason being that it doesn't have the power. In other words, if it had the power to challenge its own sovereignty, then the sovereignty in the land wasn't the all-powerful authority across that land. And so if the power that's giving sovereignty to the court isn't all-powerful, then the court doesn't have the power to make that declaration. And so it's very circular in terms of an argument, and certainly that had been litigated and tried in such cases as Coe and the Commonwealth. And so as a consequence from that assuming that we accept the legitimacy of the sovereign, then the legitimacy of the courts flow from that. We accept that the British Crown came to Australia in 1788 and claimed it, again under the doctrine of settlement, and we therefore accept that the systems of governance that are in place are also legitimate, and as a result laws enacted by that system of government are also valid in themselves. And so that those systems that create the various courts and court structures draw their legitimacy back through the chain from sovereignty. As an example of this, we'll examine the Commonwealth court system. And so, assuming that we accept the sovereignty of the British Crown, and then subsequently the colonies of Australia coming together and forming the Constitution, if we take as fundamentally that they were empowered to do that, then the Constitution itself is validly enacted by the Imperial Parliament. And assuming that we accept that is a valid enactment, then in the Constitution, in Chapter 3, it talks about and discusses and describes how a court system is to operate. It specifically states that the Parliament is empowered to issue legislation in order to establish courts for the new federal structure of Australia. Now, the most important of these is the original Judiciary Act, the Judiciary Act in 1903. That establishes the High Court. However, that's not the only federal court in the Commonwealth system. There are the federal courts that were established in 1976. There are also things such as the courts of arbitration and the courts of family law. Fundamentally, though, all of these courts draw and derive their power from Chapter 3 of the Australian Constitution. And from time to time, throughout your legal academic career and in practice, you may hear the term Chapter 3 courts being used to refer to courts that are created under Chapter 3. In other words, those that are vested with federal power. Turning now to the Queensland courts, again, if one accepts that the Queensland Constitution was validly enacted, in other words, it forms part of sovereignty derived from the original creation of the colony of New South Wales. As you're aware, Queensland was sort of carved out of the colony of New South Wales. So that if it's assumed that Constitution is a valid enactment, that gives the power for the Queensland legislature to create and establish courts in Chapter 4 of the Queensland Constitution, and those courts set out what the rights and powers of that particular court is. And again, in Queensland there is a Supreme Court which predates federation, so you actually have a slightly odd situation where the Supreme Court, which sounds like it would be the top of the hierarchy, is actually, for each of the states' courts, is actually inferior to the High Court itself, and that's just a quirk of how and when each of those courts were created. The Supreme Court is supreme within, well, originally that particular colony, and then later within that state. And much like the federal system in Queensland, there are many other examples of courts: the District Court, the Magistrates Court, and lots of more specialised courts, such as the Children's Court, the Drug Courts, and the Maori Courts. And it should be noted at this point that the court structure in each of the colonies before Federation, and indeed to this very day, vary between the various colonies and now between the various states. Now, pre-Federation, there wasn't really this strong link within Australia between the various colonies. In other words, they didn't form part of each other's hierarchy. Appeals from any of the Supreme Courts of any of the colonies would go to the Privy Council, and in fact that sort of right of appeal remained from those courts all the way up until the Australia Acts on state matters. So after 1986 and the passing of the Australia Acts, there were no more appeals. The final avenue of appeals at the Privy Council was abolished, and it's from that point forward that one can fully assert that the High Court of Australia is the top of the hierarchy. It's known as the Court of Common Apex, And importantly, decisions from the High Court of Australia will bind all inferior courts in all jurisdictions across Australia. In examining the court hierarchies of the various colonies, which later became the states, and of the federal system itself, it should be noted that each of these courts and the High Court itself has what's known as jurisdiction to hear particular matters. What that means is that each of the courts is empowered with a certain amount of scope and reach in terms of what types of matters can actually be brought before it. There are really 5 types of limits to the court's jurisdiction in each case. The first, I guess the most obvious one, is geography. So, for example, Queensland courts can only look after and adjudicate matters which occurred in Queensland, at least in part. There are rules, of course, governing things that happen close to borders, or where there are lots of facts, some of which occur in one jurisdiction, one in another. But in general, the geographical nature of a particular dispute usually isn't something that's in doubt, and so Queensland courts hear and can adjudicate on matters that occurred in the physical state of Queensland. Now, the second category of limits to jurisdiction is on substance. Some courts are specifically set up to deal with particular types of matters. So, for example, the Planning and Environmental Court is set up to hear and adjudicate on matters concerning planning applications and environmental law. Similarly, industrial courts are set up and specifically established to deal with the industrial relations issues. And specialised courts such as the drug courts are set up to deal with people in terms of dealing with particular types of drug offences, the Maori courts to deal with Indigenous people in the state of Queensland, and children's courts in terms of dealing with minors in the criminal justice system. Now, the third category of jurisdiction is the seriousness. This is a pretty common one in terms of the amount of money and or the amount of jail time in the criminal sense. So the Magistrates Court in Queensland can hear civil matters up to $150,000 and what are called summary offences, things that are dealt with in one sitting in front of a magistrate. Where the matter is more serious, and in the criminal sense it's for matters that are what's known as presented under indictment. These, rather than being prosecuted by the police and the Magistrates Court, are prosecuted by the Office of the Director of Public Prosecutions in the District and Supreme Courts. And again, only the very, very serious cases go before the Supreme Court. Most indictable offences are dealt with the District Court. So murder, for example, would go before the Supreme Court. And indictable offences, by default, you can get a jury trial for those offences where you plead not guilty. In terms of civil matters, the Queensland District Court can deal with matters from $150,000 up to $750,000. And of course the Supreme Court has unlimited jurisdiction, can hear matters beyond $750,000 or, subject to its own discretion, matters less than that. Now, the fourth category of limits to jurisdiction is in terms of the type of law that is appropriate to the particular matter. Now, this doesn't come up much in Queensland, but certainly in New South Wales, where the Supreme Court's divided up into, say, a criminal section, and they also had courts of equity, so that one could take a matter in either the courts of common law or the courts of equity, or in the if the law was of a criminal nature, it would be heard in a different court. And the final limit on jurisdiction is to do with what's known as appellate as opposed to original jurisdiction. Some courts, such as say the full federal court, has only an appellate jurisdiction. In other words, it hears only appeals. It doesn't hear matters at first instance. When we say matters at first instance, that's known as the original jurisdiction, where a matter first comes before the courts. Now, the High Court is interesting in this, in that it is the place where you can hear constitutional matters in its original jurisdiction. But for most matters, sort of 90-95% of matters that go to the High Court, they're in its appellate jurisdiction, where they're sitting to determine an appeal from a court lower in the court hierarchy, usually one of the state courts of appeal or the full court of the federal court. The High Court can hear a wide variety of matters under its original jurisdiction, matters arising under treaty, matters affecting representatives of other nations, matters involving the Commonwealth being sued, disputes between states, or in fact even between citizens in different states, and when a particular action, an injunction, or some form of administrative review is sought across or upon an officer of the Commonwealth. They are constitutional, and they are enshrined in Section 75 of the Constitution. However, in Section 76, that gives the Federal Parliament the power to give original jurisdiction to the High Court on matters either involving maritime, any other laws made by Parliament, and on matters involving the interpretation of the Constitution itself. Now that's interesting in that the Section 75 says what the High Court definitely can do. It's enshrined in the Constitution. Section 76 says, well, the Federal Parliament can give the High Court the power, in this case, the power to interpret the Constitution, but it doesn't have it by right. And now the Federal Parliament did pass, in the original Judiciary Act back in 1903, they did actually pass the ability to bestow upon the High Court original jurisdiction for constitutional matters. But as something of a quirk, the Federal Parliament could actually still repeal that legislation. And then the High Court might be in an odd situation, and then it's not given power in its original jurisdiction to hear constitutional matters. And indeed, when in the late 90s Australia was looking at becoming a republic, and a series of constitutional conventions were held, one of the issues that was actually raised was a recommendation that was to be changed, to move that from Section 76 to Section 75, so that Parliament couldn't at some later stage remove the ability for the High Court to hear constitutional matters. But the fact that didn't get much traction meant that it seemed pretty unlikely that Parliament would do that. In practice, however, the main roles of the High Court, in terms of its original jurisdiction, are very much the interpreting of the Constitution, and really that's to just determine whether laws that have been made by the Federal Parliament are actually valid. Now, this doesn't take up most of the Court's time. In fact, really, the constitutional law cases make up a very small percentage of the Court's time. Most of the appeals, so sort of 90-95% of all matters before the High Court, are actually appeals from the various states, territories, and from the federal court system. Nonetheless, the ability for the High Court to interpret the Constitution in order to then declare invalid parts of federal statutes and pieces of legislation is a very significant and important part that it plays in our overall system of governance. I'll turn now to a particular circumstance where this particular mode of the High Court of Australia was needed in terms of interpreting the Constitution in relation to validity, and that's the Tasmanian Dam case that we've referred to in earlier recordings. Now, Commonwealth and Tasmania from 1983 in the High Court, also known as the Tasmanian Dams case, is a quite long and complex constitutional law case, and it's seminal in terms of its impact in the federal-state relationship in Australia. And in really understanding its significance, it might be helpful to just take a few step backs and examine the underlying political dimensions in terms of what was happening in Australia state federal politics in the late 70s and very early 80s. Now, Tasmania at the time had a conservative government, a liberal government, and they were concerned at the time about the energy security of the Apple Island, and so that they had enacted some legislation to basically chop down some forests and create a series of dams in the Franklin River. Now, at the time, in the very early 80s, there was a federal election, and the incoming government was a Labour government, a far more progressive and left-leaning government led by Bob Hawke. And so part of Hawke's campaign, what he campaigned about, was to try and stop the damming of the Franklin River in Tasmania, and basically to protect that particular area, which was declared as a World Heritage area. Now, as is quite common, in not just in constitutional law cases, but in other matters where there's wide scope to litigate, the various parties basically threw the kitchen sink at each other. And so that when they're going through the process of litigating, and the Commonwealth in this case is the applicant, they've got many different arguments that they're trying to use in order to justify sort of striking down or some way rendering the Tasmanian legislation invalid. And so some of these arguments were that the World Heritage Properties Conservation Act, the Federal Act, it had power to make that declaration under the external affairs power. Also, they tried to argue that because there were cultural artefacts, indigenous caves, paintings, and artefacts, stoneheads, and so on, that the people of any race's power in the Constitution, Section 51, subsection 26, was a valid way for the federal government to legislate. They also argued Section 51, subsection 20, which is the corporation's power, and also ran an argument on the acquisition of property. Now, the federal government's allowed to acquire property on just terms from a state or from a person in Section 51, subsection 31. All of these arguments were presented, and notwithstanding that this particular case it was between the Commonwealth and Tasmania, all of the other states had a very, very vested interest in the outcome of this. Why? Well, because it became sort of clear when bringing this action that if the Commonwealth won, that there would be more scope for the Commonwealth to legislate over matters that had historically been the domain of the states. So in essence, they were concerned that the federal government, if they won, would increase its power at the direct loss or expense to each of the states. Now, as you may be aware, where there are two competing pieces of legislation that are both enacted by the federal and the relevant state parliaments, where there is an inconsistency between the two, Section 109 of the Australian Constitution states that the federal legislation will essentially trump the state legislation to the extent of that inconsistency. It doesn't strike down the entire law, doesn't render the Tasmanian Act in this case invalid, but each of the parts where they intersect, where there is some form of inconsistency, the federal statute will trump the state one. And so the result was that the federal government did win. So the Commonwealth did win, and the High Court was willing to accept. In particular, they were willing to accept the international agreement that the World Heritage Convention that the federal government signed up gave its scope in order to legislate over matters that concerned world heritage. And there was something of an outcry amongst the other states at the time, because there was this fear that the states were quite seriously undermined, as they had been, as mentioned in previous recordings, by things like the engineers case, the uniform tax cases, and then later late in the John Howard era, in the work choices case as well. So the Tasmanian Dams case is a very important step in terms of that shift between federal and state governments in terms of power, moving from one to the other. But in terms of the court, and the court going through and interpreting the Constitution in order to reach this particular conclusion, there's quite a useful point to make, is that the Australian High Court is not particularly interested in, when interpreting the Constitution, really about the underlying sort of substance of what's good for the country or not. That's really not the way the Australian High Court goes about interpreting these forms of cases. So really, when interpreting the Constitution, it's really looking at what the meaning is behind each of the sections there, and how taking those meanings from what's essentially quite a small document and extrapolating that out into a far more robust series of rules or principles or laws that can be applied in these forms of cases. And in the case of Tasmania, the Commonwealth in Tasmania, in that instance, they said that yes, actually the federal government can legislate on this matter. What does that mean? Well, it doesn't mean that the Tasmanian law is invalid. However, the federal legislation says that all such works must proceed with consent of the federal minister, and so who of course was a Labor minister by that stage, who was quite happy to say no to the proposal. I turn now to the role of the High Court as the final court of appeal. Now, in terms of activities of the High Court, this makes up the vast majority of the court's workload, and because of where the High Court sits in the hierarchy, its decisions are of paramount importance. So when looking at what the High Court actually does in terms of its part in the Australian system of governance, I mean, the first and most basic function of the appellate court is merely to just resolve the disputes. So, in other words, you've got two parties that have had difficulties with the law in lower courts, and you become the final arbiter, sort of going through and examining the underlying legal reasoning of each of the courts below the High Court. And an important thing to note here is that appellate courts, in most circumstances, don't rehear evidence. So basically, the evidence is heard at what we call first instance, and that it's only defects to do with the reasoning in courts and other levels of the hierarchy that the High Court is concerned about. Now, I guess in terms of its role in facilitating this and sort of supervising the mechanics of justice in the general sense, its role is first of all to promote unity amongst the common law of Australia. In more recent times, the High Court's been willing to sort of directly rebuke the courts of appeal in the States by simply saying, look, you guys are also tasked with the role of maintaining consistency in the common law of Australia. And that's been a recurrent theme throughout the existence of the High Court, but it's taken a lot of prominence in more recent times, in that the High Court was willing to say, hey, there really is only one common law of Australia. Sure, each of the states and territories have their own pieces of sort of legislation and such like, but the common law itself, and as the source of law, is really, it's very much contained within us. And as the High Court is one single authority of common law, that kind of means by extension that the courts of appeal in the various states and the territories are bound to be consistent amongst themselves. Now, as well as promoting unity, it was also the place to develop the common law. In other words, the the law-making function of the High Court is much more pronounced in that because it's the final arbiter, there are no further steps that can be taken in any particular matter. It's not bound by any other decisions of any of the inferior courts or any earlier decisions of say, the Privy Council and the British courts. So under the doctrine of precedent, it has really the sole position of being able to, by using this doctrine of precedent, to essentially make law. And it usually will only do this in situations where there is some form of gap. There's something defective about the existing system of common law and legislation that requires the High Court to map out sort of in detail what the law actually is in that case. Now, the diagram in the slide that I have there is a massive oversimplification. But it's a useful illustration, that idea that the High Court is the court of common apex, so that in this case of the state of Queensland, it will bind all courts in the state, including the Court of Appeal. But also there is the federal system itself, and so that those courts, be they the military courts, the family courts, the federal courts, the circuit court, and so on, they are also bound by the High Court. But the systems of appealing to get there, to actually reach that point where we're going to the High Court to have a matter heard, is different. And so, for example, very, very, very rarely in the very inferior courts they can be appealed. So an example of that is common power in Queensland around about the turn of the century, where a decision by the magistrate went to the district court. That was then appealed to the Queensland Court of Appeal, which actually then went to the High Court. So there were 4 steps that were taken in order to reach the final decision of the High Court in that case. I'll also note in relation to the diagram, again this is intended as a simplification, that the district court is not usually appealed to the Supreme Court itself. It's the district court matters that need to be appealed on point of law go directly to the Court of Appeal. This is just merely indicative of how and where that the courts sit in the hierarchy. And I'll also note that the structures in the other states and territories don't necessarily align with that of Queensland. I'll turn now to the other end of the court hierarchy. I'm going to spend a few minutes just discussing the Magistrates' Court and its really important role in as part of the judiciary in our system of governance. Now, the Magistrates' Court can really be thought of as a real workhorse in our legal system. The Magistrates' Court is it's an inferior court, so it has no appellate jurisdiction, and decisions made in it don't bind the courts above it in the hierarchy. And so while that might make it sort of sound like it's unimportant, in fact it's very, very important in terms of our system of government, because most matters, and I'm talking sort of 95% of matters in Queensland, go through, at least at some stage, the Magistrates' Court itself. To give you a feel of what sort of numbers the Magistrates' Court received, in the reporting year 2014, 220,000 people, defendants, were dealt with by magistrates in those courts, facing a combined total of about 400,000 different offences, that including both adult and sort of and juveniles under the Children's Court jurisdiction as well. So you're dealing with just a massive caseload in this particular part of our system, and we sort of compare and contrast that with the High Court, which sees between sort of 50 to 100 matters per year. In some years, certainly earlier in the history of the High Court, even fewer than that. And it's important also to know that the Magistrates' Court is the place where most people will interact with our system of justice and the system of governance. It's sort of like the grassroots court, and it's one that, in terms of visibility, more people are likely to experience and spend time with and interact with the Magistrates Court more than any other level in the hierarchy. Now, when I note there that Magistrates Court is a clearinghouse, that's because while many matters are dealt with directly by the magistrate in what they call a summary manner, whereby the magistrate acts as essentially both judge and jury on a particular matter, to deal with the particular offence there and now. That's a very common way for minor charges to be brought against a person. The police will prosecute in the Magistrates Court, and the matter will basically be resolved in one sitting, with the magistrate both hearing evidence from both sides, making a determination, and then, if the person's found guilty, determining the appropriate sentence in one fast sitting. Now, another important function, though, in the Magistrates Court of Queensland is what they call committal hearings. Basically, when there is some evidence of a serious crime, or what they call an indictable crime, that would need to go to the District or Supreme Court, it actually starts in the Magistrates Court. And so the various parties, the police and the defendant, will bring along evidence, not proving things beyond reasonable doubt, as would need to be done in trial, but just determining whether there is a sufficient amount to justify actually putting it to trial. This is a very important function of the Magistrates Court, and it's also very cost effective, in that where a case is just on the surface of it very weak against the defendant, there isn't even that barely sufficient amount of evidence to bring the action, the magistrate has discretion to not send things to trial, and thus sometimes saving the state a large amount of money. Another point to note about the Magistrates Court is that the court can be construed in another light, or given another name, such as the Drug Court, the Coroner's Court, the Children's Court, and as of last year, the Murray Courts have been reconstituted. And so the magistrates who are appointed as magistrates and have tenure will go and sit in those particular courts to hear matters of particular substance, be they with minors, to do with drugs and drug law and users, and with Indigenous people and elders in the Murray Courts. Why do they do this? Well, as well as having and being a more accessible system of justice, there is a cost aspect to this. The Magistrates Court hears a very large volume of people before it in its criminal jurisdiction, and as a result, there are large chunks of people to whom going before, I guess, the regular conventional Magistrates Court is quite inappropriate. For example, minors and persistent drug users, and those with mental health challenges. And I think it's important for those undertaking this particular subject, as part of one of the tasks that you do, is to actually attend one of the local magistrates' courts and just watch and listen to some of these cases. And really that idea that people in the criminal justice system can best be dealt with by a specialist court, one with expertise and particular legislative powers to do and take actions that the Magistrates Court in its general setting cannot. One of the problems that then arise from this, as you might reasonably see, is that there's then some form of perception that people in certain groups, be they minors, be they Indigenous people, be they habitual drug users, are somehow not subject to the same laws as everyone else. In other words, this idea of having separate distinct distinct courts some sort of affront to the rule of law. And this is and has been a political issue that's that's been juggled about by political parties over the last few decades. So I guess one argument for having these structured specialist courts really just flows from the sheer volume of matters the Magistrates Court has to deal with, and the sort of the demographics of people appearing, occasionally self-represented, and in terms of needing to do that, having these separate courts gives the magistrates the power and flexibility to deal with these matters, to sort of dispense justice in a far more effective manner. And I think that's partially because the Magistrates Court is the one that people are most likely to see, and so as a result there's the public in general has more awareness of its function, of the other people that are in there, because they've often been more involved with it. It's that whether you've been in there yourself or known somebody or had a friend or family member that's had to deal with particularly minor criminal offences. And so that as a result the Magistrates Court really to operate effectively needs to maintain and have some quantity of flexibility and that ability to change and adapt with the times. In this final part of the recording, I'm going to talk about the separation of powers doctrine and some problems, in particular how the separation of powers doctrine can be undermined, in particular through the manipulation and the appointment and the removal of judges themselves. So when I refer to the concept of judicial independence, it's really a mechanism of trying to separate as much as possible the judiciary from the other two arms of government in order for them to be seen to be impartial and independent of usually the government of the day. And let's just draw back to the fact that the executive, the heads of the executive, consist of all of the ministers of cabinet, MPs of one particular ruling political party. And so some theorists argue that the independence of the judiciary is very, very important, particularly in the Westminster model. Now, judges are appointed under certain parts of the Constitution. So the Section 72 gives ostensibly the Governor-General the role of appointing judges, and in Queensland, Section 59 of the Constitution Act 2001 allows for the appointment at the request of the Governor. But as we're aware from earlier in this subject, a lot of the powers that are bestowed upon the Governor and the Governor-General to perform in this way are really done at the request of the government of the day. In other words, they're reserve powers that the Governor-General and Governor can do, but by convention do not do. And so this appointment process is really a political one. Now, the various parties, governments that are in power at any particular time when a judge is required to be appointed, can go through and consult with parties. They can consult the profession, they can consult the community, but really in practice it still fundamentally is a political decision. And while Australia and Queensland aren't really at the same stage that the US are at in terms of their appointments, there is still a tendency for, I guess, progressive left-wing governments to appoint more progressive judges, and vice versa with more conservative ones. One of the quirks of this is that because judges have tenure, in other words, they are given their particular position usually until a mandatory retirement age, which is 70. The date of appointment can be from when there is either a very progressive or a very conservative government, but that particular judge can remain in the system for many, many, many years afterwards. And In the appointment of one judge, particularly to the appellate courts, to the courts of appeal of the states and territories, or to the High Court, often doesn't change, I guess, the flavour of the court itself. So, for example, if the court is predominantly made up of conservative judges, appointing one very progressive judge to that court, it isn't necessarily going to change the outcome of cases immediately. It's something that may influence and change over a long period of time. One of the sort of long-standing criticisms of court, particularly the appellate courts in Australia, is really to do with representation. Now, since the court first sat in 1903, the overwhelming majority of High Court judges have been white, Christian, educated in private schools, male, wealthy, and who attended generally the large prestigious Sydney or Melbourne universities. Very, very few have been women, and of those only relatively recently with the appointment of Mary Galdron. And there's never been a High Court judge from a non-English speaking or Indigenous background. Now, one of the problems that comes from that, having a very narrow sort of representation of social groups, is that the court can give the perception that there may be some form of bias. And while certainly members of the court will very sort of staunchly and strongly assert that that's not the case, the perception remains nonetheless. And so there are these arguments sort of for and against the idea of having elected judges. So at the moment we have a system of appointment where judges are appointed by the government of the day. Other systems, again, drawing on the American experience, they have elected judges. Now, while they may seem to be representative more of the people, in practice, most judges actually generally tend to be from an Anglo-Saxon sort of background, wealthy males with a lot of education. And the processes of having these elections can be problematic in themselves, in that judges seeking to campaign have to spend money. They have to go and obtain campaign funding in order to sort of extol their virtues and advertise the fact that they're running for a particular judicial office. And certainly, from our system and our perspective in Australia, that seems to be just fraught with danger in terms of how and where money sits in that particular system. And so, from our system, when judges are appointed, that can actually be extolled as a virtue. Look, hey, these guys who the government of the day is appointed, and importantly, given tenure for life, they're not subject to the turning of the tide in terms of popular opinion and the changing of political parties. So they can essentially function as some form of a break to what can sometimes be some quite awful populist views. So, for example, the sort of anti-refugee and boat people cases that have come before the courts over the last sort of 10 to 15 years. Well, the argument there being that the courts, they're not quite as influenced by what the majority thinks, and are in a far better position to protect the rights of both citizen and non-citizen. I'll turn now to the appointment of judges. So if we look at the Constitution, both of the State of Queensland and of the Federation of Australia, the latter document actually doesn't say very much about what the requirements of a person are in order to become a High Court judge. All it says is that they have to be less than 70 years old. The Queensland Constitution is a little more verbose in that a person must have been a barrister or a solicitor in the state of Queensland for 5 years. Now, in practice, people that are appointed to be judges invariably have been in the legal system and been involved in cases for much, much longer than that. But it's interesting to note that there is no actual fixed criteria for people to become judges. Now, there's a lot of commentary on this in terms of whether things should go to some form of committees, whether there should be some form of third-party impartial body to examine this. But again, the same argument that's advanced with in dealing with things in terms of judges comes up again with this, in that the person's in a best position to judge, I guess, the caliber of a person is a judge themselves. And so we have this this sort of problematic cycle of then you would have essentially judges being heavily involved in the appointment of other judges, and so that itself looks particularly problematic from the public's perspective. And so perhaps the current situation where it is essentially a political appointment of the Attorney General is possibly the best the best choice amongst a series of bad options. Another thing that comes up in terms of the process of appointing judges to the sort of superior appellate courts is the difficulty with remuneration. Now, judges, I guess by standards of the average citizen, are very, very well paid, with the Chief Justice of the High Court taking home about $500,000. Similar amounts are awarded to the state courts, ranging between sort of $350,000 to $450,000 per annum before tax. Now, one of the reasons for what seem to be quite large salaries is the issue of bribery. It's something that is, I guess, a structural problem that our system of governance in our Western liberal democratic tradition is that we don't want elected officials and appointed members of the judiciary influenced by money. And so subsequently the only way around that is to pay them a lot. Hey, if you're paid a lot of money, you'll be less tempted by offers of bribes and corruption. One of the sort of interesting side effects of that was noted by former Chief Justice of the High Court, Murray Gleeson, who wrote an article on the fact that often when he was sitting as Chief Justice of Australia, he was the least paid legal practitioner in the room. That is, the very, very top barristers and those that are proprietors of the large law firms earn significantly more than the highest paid government officials. And I guess the counter argument to that is that people seeking these sorts of offices are often not doing it for the money. They're doing it for to both advance themselves as persons. Some have a sense of sort of social justice. Some very much want to view it as being the apex, being the absolute pinnacle of achievement in a particular field. And those views are pretty valid. The idea that becoming a judge on the High Court is really the top job that a person could have in Australia, even if it's not necessarily the most well remunerated. Now, another really important feature of judges in our system is security of tenure. And this ties up very much with that idea that judges need to be very well paid, but also they have to be secure in their position of judicial officers so that they're not subject to the discretion and whims of the government of the day. In other words, political decisions to remove judges is a really bad thing, and we try very hard in our system of governance to make this cumbersome, or at least make it such that in order to remove a judge there must be a very, very thorough process and very, very good reasons in order to make this happen. And certainly we see this playing out in other countries where they don't have this security of tenure, and for political reasons you see places like Pakistan and recently in Turkey where in times of political crisis the president just elects to sack certain judges that she or he doesn't find agreeable. And so there is political pressure placed upon judges, and sometimes that goes the other way too. So very, very rarely do judges sort of make forays into the political spheres. But actually quite recently in Queensland, the President of the Court of Appeal presented an article in one of the major media outlets about the role of the then Attorney General under the Newman government and the political interference, the problematic nature of some legislation, and then later the appointment of Justice Carmody to the role of the Chief Justice. All of these things were actually expressed in the public sphere. Now, by convention, the Attorney General is actually supposed to act in some ways as the mouthpiece of the judiciary. In other words, be the public defender and upholding public confidence in the system. And so when there is a very strong, very clear breakdown of relationship between the members of the highest court and the government of the day, this can be problematic because it undermines public confidence in the entire system. And it does get you sort of thinking about, well, if the government of the day doesn't like the judges in the appellate courts, what process could they do to go through and remove them? Fortunately, in Australia, and in particular in Queensland as well, the removal of judges is a very structured affair. In the Australian Constitution, in Section 72, it actually states that judges appointed under Chapter 3 shall not be removed except by the Governor-General and Council in an address from a joint sitting of Parliament, and only on the grounds of proven misbehaviour or a lack of capacity. This, as you quite reasonably could gather, is a very, very difficult test. It's a very very structured and complex method for removing judges, and it's not helped, unfortunately, by the interpretation of proven misbehaviour and incapacity. What exactly does that mean? And I guess more importantly, when we're trying to determine what that means, the role of interpreting the Constitution is of course left up to the judges of the High Court. And so in the case of trying to remove judges, that's a little bit problematic. And certainly in the 80s, when Justice Murphy was charged with two criminal offences, Parliament established a separate body, a commission of inquiry, in order to establish this. Now, the results of this never really came to fruition because he actually died while the process was going on, and so that where we're at in Australia at the moment, in the federal jurisdiction, under Section 72, the actual process for doing this hasn't really been mapped out or demonstrated to any great effect. Now, in the state of Queensland, they have had judges removed. Justice Barster, the proven misbehaviour in that case was that he gave false evidence in a defamation case and falsified his tax return, each of which made him unsuitable to remain as a judge. Other mechanisms that the executive can go about removing judges that the government of the day doesn't like is simply to abolish the court that judge sits under and replace it with another one. That happened with the Industrial Relations Commission, removing Justice Staples, who by this stage there were some personal issues in terms of his relationship with others on the bench as well as with the governments of the day. Now, usually in those situations, judges by convention will resign, and even going through the process of removing a judge, even if there is a pretty good reason to do so, it can undermine the public's confidence in the judiciary and the system of governance in general, and that in itself can be very problematic, notwithstanding any loss of confidence in the judge personally, in terms of their personal reputation. And it's a phrase that comes up a lot, both you'll have in your formal legal academic training and in practice, that idea that as a legal practitioner, your personal brand is pretty much everything. You build that up over over your entire career, and it can all come crashing down, sometimes under the most innocuous of circumstances. So, for example, Marcus Einfeld was a retired judge, retired in 2001, but he was actually jailed subsequently for the most inane reason. He lied about a $77 speeding fine. He wrote on the declaration that the car was actually driven by a friend of his who lived in the US, and some journalists actually noticed when sort of uncovering this that, hang on, that friend actually died 3 years ago. And so just through unraveling this process of Marcus Einfeld's lying about that, he was then charged. Now, as it happens, after you're retired, there's no actual requirement for judges to maintain the same standards of propriety, and he was still entitled to his pension. So that there were some calls at the time that perhaps that particular law in terms of judges' pensions ought to be changed, but it wasn't. The final point that I wish to make about the tenure of judges is to do with retirement. Now, at the time of Federation, when the Constitution was originally drafted, there was actually no mandated retirement age for judges sitting on the High Court. And so, just as a bit of history, in the mid-70s, there was something of a personality clash between the then Chief Justice, Barwick, and Justice McTernan. Now, McTernan was quite old by this stage. I mean, he was in his 80s, and he'd been sitting on the High Court for a very, very, very long time. In fact, he was first appointed in 1930. And so in 1975, he was on circuit and actually broke his hip, and the Chief Justice refused him a wheelchair ramp. And so he was sort of effectively forced into retirement at that particular point in time. And he commented afterwards that he would quite happily have continued serving until the day he died, which incidentally was 1990, when he was 97 years old. So you've got at the time there was also calls for a referendum on a host of issues, and one of the issues that was included in the 1977 referendum was to actually incorporate a mandatory retirement age and set that at 70, and that passed through that referendum at that time. And so that High Court judges in Australia at this present point in time must retire on or before their 70th birthday. Now, the same date is actually the same in the state of Queensland. However, it's not fixed in the Constitution of Queensland. It's actually established by legislation in the Supreme Court of Queensland Act, the 91 Act. And so, in theory, the government of the day could pass legislation to increase that. Now, when thinking about the retirement of ages of judges, just note, first of all, that the retirement age of all other citizens was actually increased by Kevin Rudd a few years back from 65 to 67. And so there are some calls among some parts of the community that, well, perhaps the age of judges could be increased as well. I mean, after all, people are certainly living longer than they were in the mid to late 70s. However, there is also the contrary public opinion that the judges, by and large, who are old to start with, aren't representative of the people, and that it would be more appropriate for younger judges to be able to more appropriately represent the public and popular sentiment at any particular point in time. Another problem with setting a mandatory retirement age for judges is that in order to be very competent and become a judge, and particularly in the higher appellate courts, arguably a person needs to know a lot about the law and to have a very wide breadth of experience. And this is something that can only really reasonably happen after a very long career, often as a solicitor or barrister. And so perhaps it is problematic for there to be this mandatory retirement age. Possibly just the fear of, particularly of senility, setting in, and that worry that judges sitting on cases, as they get a little bit older, start to lack the, the necessary faculty in order to judge cases, and sometimes very, very complex cases. And all of these things, they're really just discussion points that may be helpful for you to think about when trying to determine how and where the judiciary, our court system, sits really in our entire system of governance. Just one final point about the retirement of judges that may be helpful to think about for those that are seeking to enter into the legal profession, and that's when judges retire, they've built up over the course of their career a huge amount of knowledge, and when they retire, in terms of the system of governance that we have, that in many ways gets lost. And it's worth thinking about that idea that the judges, as people, as human beings, build up themselves as a repository of the law, and it may be very helpful for those seeking entrance to the profession over the next few years to really think about that idea that over time you're going to become repositories of the law yourself, even if you're not going to enter into to become magistrates or judges, but you're going to know a lot about the law, and how you go about using that is really something that you should just be very thoughtful about, and to actually think about where you're going to go and how you're going to use and apply the knowledge that you acquire.